thank you again so much, and I hope you have been engaged and really learning a lot throughout the first part of this day. So on this panel, this is the Community and Courts Bail Implementation Panel. What we have are among our esteemed panelists are practitioners and folks who are watching what's happening on the ground. So we've learned a lot about what the legislative intent was in preparing the statute and writing that statute. You know, this intent to lean on decarceration, reduce the number of people who are experiencing jails and prisons here in New York State, address wealth-based disparities, as well as begin to mitigate those racial and ethnic disparities that we see throughout our criminal justice system. And we know that that intent, of course, gets reduced to text, and how that process happens can be often cumbersome, right? There are some compromises that are made. There's language that is used in order to codify these intentions. We also learned from the research perspective, what are some of the outcomes we have seen throughout New York State in terms of the changes in the jail population, the use of bail, the amounts of bail. And what we are hoping to turn to now is, what does all this look like at the stage of implementation, right? What are the folks who are spending their time in court, in arraignments, surrounding arraignments, watching from a community perspective? What does this mean in practice, and what are some of the challenges that have been experienced on the ground? So I'm very grateful to the panelists who are joining us this afternoon, and thankful for all of you who have returned after lunch break. So for what I also want to remind the audience, those who are watching remotely, those of you who are here, we're taking questions in a few ways. We have a Twitter account. We're using Twitter with the hashtag NYBailConference. So if you feel like tweeting a question, please do. I have colleagues who will assist me in getting those questions. And we also obviously have this space, and we will be taking questions directly from the audience. So if anybody, we'll start with some discussion. We'll turn it over to all of you for some questions. And just one note that DA Soares may need to leave a bit early, as our schedule is kind of running into each other, but we are really thankful for his time, as well as the time of all the panelists here. So I'm going to go, I would like to introduce everyone. I'm going to give a brief introduction, starting from my left to my right, so you all know who they are before they start speaking. Okay. So I should say, I don't believe I introduced myself. My name is Krystal Rodriguez. I'm the Policy Director at the Data Collaborative for Justice here at John Jay. And immediately to my left is Martha Bailey. Martha is the Executive Director of the Wayne County Pretrial Services. We have Sarita Daftary, who is Co-Director of Freedom Agenda. Youngmi Lee, who is Legal Director of the Criminal Defense Practice at Brooklyn Defender Services. And we have Awinna Martinez, who is the former project director of the Staten Island Justice Center of the Center for Court Innovation, and the Honorable David Soares, the Albany County District Attorney. So I would like to ask of you all just a general question to sort of give people a picture of what all these numbers and legislative text translates into on the ground, right? So, and I'd like to start with DA Soares, if that's okay. Considering the goals of the law and what we've been learning about and discussing throughout the day, could you share from each of your perspectives, what about implementation has gone well, or what are some things you have observed as deficits or challenges to implementing this bail statute?
Okay, interesting question. So the only way that I could relate the experience in what I think is a relatable way is when I'm an immigrant and you come to this country, you have your first Christmas, and you get this box. It's Matchbox cars. Box is beautiful. You open up all the toys and you realize batteries are not included. and there's some assembly required. And so when you get such transformational policy, well-intended as I'm sure they were, there are no directions that come with it. And in this instance, neither was there any funding. And I think oftentimes, as it happens in Albany, whenever we have major policy shifts, those policies are often developed with a New York City-centric perspective. In other words, I understand that George Washington Bridge, that there's a wall, and the rest of us live north of the wall. If you're a Game of Thrones fan, I think you might understand. And I say that just because the ecology of our criminal justice system in upstate New York is much different than it is here in the city. So, to give you an example, just in my jurisdiction of 300,000 people, we have the most diverse of communities. We have an inner city, we have river towns, we have more rural hill towns, and we have bedroom communities, all of which have a court system in each of those communities. In Albany County, as I'm sure in other upstate communities, the organization that is primarily responsible for pretrial services is probation. Unlike certain communities here in the city that have not-for-profits that are responsible for pretrial services. I think what is interesting, and something that we'll probably get to, is determining whether there is a difference in pretrial services when those services are offered by an institution that is connected with the criminal justice system, as opposed to one that is in community and community-based. I think that's a relevant issue to study. As I said, batteries not included and some assembly required. These transformative programs did not come with funding. Upstate communities that also experience a 2% tax cap are also challenged in, I think, providing the kind of services that perhaps others are experiencing here in New York City. It would also be interesting to see whether there is a correlation between outcomes based upon funding. In New York, in Albany, New York, what we're experiencing now in the courts is as a rate of return. If you're talking about our city court, which is open every day, and people have access to that courthouse every day, even for arraignments on the weekends, we're seeing a rate of return of about 50%. In our local courts, we're seeing, in our town and village courts, we're seeing a return rate of about 25 to 30%. And what does that mean? Giving you an example of a community in my jurisdiction, Colony. In Colony, you have 2 courts and 3 judges, and they rotate, right? So their policy in Colony is 3 strikes, and then you'll get a failure to appear a warrant, right? When you're on a rotating schedule, those 3 strikes take 9 weeks to achieve. So we're not seeing individuals back for months at a time. And then if they're not returning on that 9th week, you're on that same rotation. Now, what does that mean? Well, that means for individuals who are presenting not only with a criminal charge, but also presenting with some other need, for example, treatment, which they can get connected to, they're not receiving, they're not getting access to that treatment, which is an issue. And I'm interested in hearing how other communities are wrestling with those issues. I was told with very threatening eyes on a Zoom call that this was not going to be a discussion about opinions as to whether bail reform was a good thing or a bad thing, so I'm sticking to my script under the threat of harm. But I would leave you with this. It's not just enough that there's advocacy for change in criminal justice policy. There has to be advocacy to make sure that there is support if you want those policies to succeed. And I think one of the challenges that we're experiencing north of the wall is these programs succeed. And I think a lot of it has to do with just the woeful funding for an investment towards success. I agree with people who say that people whose needs are being met are not out there committing harm to other people. And I think right now we have the same condition pre-existing bail reform where people's needs are not being met. And so we have to figure out how to address that. Thank you.
Thanks. Martha, I'd like to turn to you to focus on that general question around the deficits or challenges or maybe things that have been going well in implementation. But with the additional focus of zeroing in on something DA Soares just shared regarding the support needed for policies to succeed. What is not just the financial support that those policies need, but what are the specific ways those resources would be directed in order to address whatever challenges or deficits you might share?
So I'm from a county where there's around 90,000 people. We are a very rural county where we are a completely community-based agency, a nonprofit. We are not part of probation. Our relationships within the criminal justice system is very important with all the stakeholders there. Our relationships with the human services agencies is essential. And then our relationships with the individuals that are getting placed on release is, it helps our success, quite frankly. I was here earlier and there was a sheriff who spoke on he knows the people that he's arresting. We know the people that are getting placed on release, and there's a trust that all of those people place on us. Along with that, we were expected to do a lot more with the same amount of funding, and that it proved to be a huge challenge. We have very little transportation. That's a huge challenge, is trying to figure out how are people even going to get to court. When it was virtual, how are they even going to attend court virtually if they don't have access to the internet or access to a cell phone? Those are things that we had to face on a very limited budget. We use technology a lot, but one of our biggest strengths, I think, is how to make it a human interaction with the people that we're helping. We're able to give them access to services that could, in reality, be life-changing for them. Does that answer your question?
Yes, 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 that was very helpful. So some of the things that I'm hearing is that the relationships is what allowed you to sort of build in the implementation, right? Like you were able to connect people to services because you had these pre-existing connections with community service providers. I would like to turn to Awinna, who is former director of Staten Island Justice Center, oversaw supervised release here in New York City. And what I would like to ask you is, what are some of the challenges you saw and how did you overcome them as it relates to this service provision, right? This ability to connect people directly to the services they might need. And I'm going to tackle another question. What are the services you think are most needed, most prevalent in the folks who you're seeing coming through your program?
Yeah, so first and foremost, we talk about data and numbers and the intent of the law, and behind every number is a person, with needs, with their own story, who's tied to community, with family. And so, a really big obvious answer to that is funding and resources. So the Staten Island Justice Center and the Center for Court Innovation had been operating supervised release programming since 2016. It was operating on a smaller scale. There were eligibility requirements. So we had 4 or 5 years of experience under our belt servicing the Staten Island community. We always said that supervised release, the whole point is to get people back to court, but it's so much more. It can be so much more. And so when the bail reform legislation happened, our resources increased. We received more funding to hire more social workers and case managers. At the time, 2019, we had a very small team of 4 or 5 people who were working with our clients every day, providing them with resource allocation, even something simple as, I have a case manager who I can call and just talk to. That human-centered approach, that human touch was really important for someone who was going through a very difficult time in their lives. And so with the expansion in bail reform, our funding increased. And so we were allowed to increase.
She's hating on you over there.
This is the goal, right? The goal is to increase resources across the state of New York, because we went from a team of 4, 5, 6 people to over 30 in a matter of 3 years. And that allowed people to have smaller caseloads, more attention paid. They're able to catch any specific needs that someone is coming to us with. So I would say that the biggest answer to that is really us having the ability to hire more staff, so that we could have more of this human-centered approach, and if someone's need is just, I'm going to call once a month because that's what my supervision level requires and it's all I need, that's okay. But like I said, it was return to court, but it can be so much more. So providing resources, if someone needed diapers or formula for their baby, we provided that. When the court shut down due to the pandemic, and we had to go to video court. We were able to provide phones, smartphones, so resources really went a long way. And I would really say that you would think a pandemic would affect compliance. Our compliance got better during that remote period.
Could I ask a follow-up question, Awinna? Speaking of your caseloads, right? How did you expect caseloads to change given what was written into the statute? And then what did you actually witness and observe in terms of the caseload? Any characteristics of the folks who were coming through the program? Yes.
So prior to bail reform, there was an eligibility cutoff. If you rated high risk on an assessment, you were not eligible for supervised release. So with the expansion of charges, there was no eligibility criteria. We were hoping and we were anticipating seeing more felony level charges coming in through supervised release, so that misdemeanor level offenses could be ROR'd, and we would have more of the resources and time to really work with those folks coming in through the system. And so we did see an uptick in felony releases at the tail end of 2019 when we did launch the new version of supervised release. But that slowly kind of trickled down. I think the excitement or the judicial kind of pressure to release people out of Rikers, this supervised release program is here, I will utilize it now. So that did attribute to an increase in felony releases to us. However, throughout the year, the past 2 years, we've kind of seen more of what we used to get. It's just kind of like 60%, 40% misdemeanor majority caseload. So a lot of our folks that were coming in on misdemeanor offenses, and it continues to be that kind of breakdown.
Mm-hmm. Mm-hmm. And just following up on that, I'd like to turn to Young Me. Awinna notes this change or this shift in the folks who are being sent to the supervised release program. And so from your experience, why might that be? What is contributing to that? And, how might that be an implementation challenge for this bail statute?
Sure. So Brooklyn was an outlier jurisdiction in all of New York City since supervised release occurred in 2016. And this was pre-bail reform. And we were the outlier because we had many more misdemeanor cases on supervised release than on felony cases. And so it seemed that with judges, even though cases were eligible for supervised release, they would rather set money bail on the felonies. Whereas on the misdemeanors, they were more likely to do supervised release. And so there was a real concern that people who should have just gotten straight release without any conditions, were getting supervised release anyway. And so we were very concerned about that over-programming, over-supervision of people who are presumed innocent. So Brooklyn was like that for years, and then we had bail reform. And the hope was, because pretrial services in New York City, we call it supervised release. Pretrial services is the generic name. Supervised release is the name of the program in New York City. And so every case, no matter how violent the felony, is eligible for pretrial services. And if judges are applying the least restrictive standard, which is the new standard under the bail reform laws, you would expect to see an increase in the number of cases, whether it's a felony or a misdemeanor, getting supervised release. And we're not really seeing that difference. And I think part of the problem is that when we're talking about whether bail reform is a success or not, what's really important to keep in mind is that for decades, we all, and I'm, as a defense attorney, we all caused a lot of harm with the bail laws, not just on individuals' lives, that person with the 30 misdemeanor convictions who kept pleading guilty just to get out of jail because bail was set on a petty larceny, but also on whole communities. And so the expectation that we got this amazing bail reform, and it is amazing, it was really transformational throughout the country. The expectation that we would have overnight success it's really unrealistic. And so what happened was we had the fear-mongering, and I'm sure it was all discussed this morning. And even before we could try to measure a little bit of success, we had rollbacks, right? So in 2020, even before implementation could take place, the legislature, the governor, they scaled back some of the bail reform without evidence, without data. And then unfortunately, the pandemic hit, and those who are without money, who need the services the most, were hit the hardest by the pandemic. And even pretrial services, supervised release, they had to go into a virtual supervision, which we all know when it comes to the one-on-one counseling and the face-to-face encounters for people who really need services, that is not going to be as effective. So we have the pandemic, the people who are hit the hardest by the pandemic, their lives are even more upturned. And then again, we're trying to measure the success of bail reform, given these harsh conditions that are happening across the country, not just in New York State, but across the country. And we're still trying to measure success. And then we get to 2022, where we're scaling back bail reform again. And again, it was so clear, so very clear, that there was no data to back up what was happening in terms of whether bail reform was working, whether it was really affecting public safety, and the conversation just turned south again based on a nationwide epidemic. And so when we're talking about implementation and whether judges, and I have to say, there are plenty of judges in Brooklyn who are using all the tools that are within the bail reform statutes. So we have judges who are really taking seriously the partially secured bond option. We even have a couple of judges who will, and I would love to see this happen more, the unsecured bond for those bail eligible cases where judges feel that bail should be used as an incentive to bring someone back to court, right? Because that's what bail is about. Or utilizing maybe pretrial services more. And I think part of the problem with pretrial services and why it might not be, why it's not being utilized more, especially on the qualifying offenses, where instead of bail, judges should be using pretrial services, is that maybe there's a misunderstanding about pretrial services, which in New York City is pretty robust. We have supervised release. There's an intimate partner violence component to it. They do voluntary referrals. People don't realize that some people who need services but don't want a court mandate and don't want to be forced into treatment are availing themselves of the voluntary referral services. and going and doing services quietly on their own. And we have actually had lawyers who will say, oh, my client's doing pretrial services, they're doing well, they're doing their weekly check-ins, or if they're on the least level of supervision, their monthly check-ins. But guess what? They're also doing a program on their own. And now I'm going to use that to get a plea disposition on the case for those who want to plead guilty. And so there's no coercion, there's no use of bail to force people into pleading guilty so that they build up a record of having 30 convictions on really low-level offenses. And I think when you look at these individual cases, that's how you mark success. Overall, the big picture, when you're looking at data, I think it's going to take a while to measure true success if you're looking at large numbers. But in terms of individual lives, those who don't go to Rikers, many of them are doing really well.
Or should I give you?
Well, yeah, because I think I couldn't disagree with you more on some of the things that you said. I think we can all be in agreement here and talk about the need for additional services. I think this idea that we're not seeing an increase in crime because of what's happened with bail is absurd. Now, I don't practice law in Kings County. I practice law in Albany County. And when you talk about numbers, I mean, I don't understand what you're talking about when we have people who are released that otherwise would not have been released, reoffending. But I don't want to get into the debates of whether or not there's reason to roll back or not. I think we should be joining together and calling for our leadership to call for research and studies and testimonies and allow for every jurisdiction to come forward and present their information and then be able to assess whether or not something is working. Because when you say we don't have numbers and there's no evidence, well, I have evidence in my office. I have evidence in my office of people who are committing atrocious crimes, being released and doing more harm. And it's concentrated in one community. And so the question then becomes, how long do we have to ask Black and brown communities to continue enduring the suffering of violence because we want to establish that reform and equity is a good thing? I'm not going to get into the merits of whether it's a good or bad thing, because I said that I wouldn't do that and distract the conversation from the desperate need for resources so that everyone is operating at a Staten Island level. But I think it's incumbent upon us to ask the leaders who passed the legislation to in this next term to come to Albany with the idea and the thought and plan to have a greater discussion.
And could I, sorry, I just wanted to bring Sarita Daftary into the conversation. I know that you are doing work that is connected to individuals who are most directly impacted by the bail reform law, court practices, judicial decision-making. From your perspective, what are some maybe pitfalls of how implementation's been going? What are some strengths, if there's any that you've observed, of how implementation has been going?
Thank you, and it's hard not to jump into that, but I'll try to respond to what you said. And I'm the co-director of Freedom Agenda. We're a membership group, so our members are folks who have been incarcerated on Rikers, whose loved ones have been or are incarcerated now. And so I would say that a lot of what we're seeing is actually certainly what we see as the deficits and challenges in terms of the people who are still there and all of the ways that judges are still using their ample discretion to incarcerate. What we are seeing is that unaffordable bail is still being set. And that seems really obvious. That's maybe not like a news flash to anybody, but maybe we should pause a second on what that is. So people are still being held in jail in New York City, a jail that has been called by a federal monitor and its own oversight board a deadly, dangerous place, and where 20 people have died in the past year and a half. People are still there rather than home awaiting their trial while they are presumed innocent because they didn't have enough money. So if that was happening one time, that would be too much. It is happening thousands of times over, and that's the situation we're in. So that's what we're seeing. What we're seeing through the lived experience of our members includes, I feel like every piece of what we've talked about today in terms of the ways in which the intent of the law is being skirted. So let me give a couple of examples. One of our members who her son has been on Rikers for the past 2.5 years, struggles with mental illness, had his bail set at $75,000 cash and $250,000 partially secured bond, was not able to pay either, and has been so distressed in the environment in Rikers Island where his mental health has deteriorated, that he's not made it to his past several court dates. Of course, this is Rikers Island, so nobody really knows if corrections failed to transport him or if he refused because he was having a mental health episode. But so his time there is being dragged out even further. Another example that I would say is the use of the way in which people are still blocked from treatment courts. And treatment courts are already not the ideal, right? Like, you don't want people to have to get arrested to go get services. But if people have been identified in the process of an arrest and come into the court system with a clear need for services and for treatment, you want to be able to divert them. But still, we see, because the current statute allows prosecutors to act as the gatekeeper, we still see some prosecutors slamming the door on people who need treatment. And so we have a member who has a case right now. The judge in that case actually has said that he's very open to an alternative, very open to treatment. There's a clear need. They did an evaluation. It seems like there's a clear need for treatment, an intensive treatment for her son. But the prosecutor just won't consent to the case moving to treatment court. And so he remains on Rikers, exposed to more and more violence every day. And I think the people have some sense of the environment on Rikers, but it's an environment that requires violence in a sense. Like, people need to be prepared to defend themselves. And so the way in which that perpetuates violence is completely counter to public safety. And certainly that's what we're hearing from our members. We're also seeing that we've been looking a lot at the way that judges are implementing bail reform, basically because we want to know, we want to know how this is being implemented, but also because judges are going to continue to have some discretion. I mean, like, the whole bail reform fight has been about, like, how much discretion they have over which cases, in certain ways, but we're not near a system where judges have no discretion. So we are interested in seeing how are judges using that discretion. And we started looking into it more in probably around the summer of 2020, when, in response to concerns about the spread of COVID in jails, there was like a wave of willingness for release. And what happened was that, people who were serving short sentences were released. People with being held for accused of parole violations were released. And then we were sort of looking at, like, what's next and what's left, and it was all pretrial detention, and it was clear that in that case, it was all judges, like the people that were going to make the difference in whether a person was going to get out or at that point, and be able to be, in a safer setting, not in a congregate setting during COVID, was all judges, and we wanted to at least engage in that conversation about what is influencing judges, because I think we sort of felt like the common knowledge is that judges are immune to public pressure. They're supposed to be these removed figures. But what seemed more the case was that they were actually responding to the wrong pressure, that they were, sort of acting out of a desire not to be named in the New York Post, rather than really thinking about, how am I applying a law that requires me to use the least restrictive conditions, that requires that I at least consider ability to pay, which you can't do if you're not assessing ability to pay, and neither of those are happening.
And then, that restricts me to looking at a person's likelihood of return to court. And what we see is not that. It's that repeatedly, bail amounts and decisions about release, they're really based on the charge. And so when they are based on the charge, that's a stand-in for dangerousness. So it's not, we don't have a legal statute of dangerousness, but we have judges, sort of informally, and I would say, outside of the law, using dangerousness all the time. And if we were serious about wanting safety, there isn't data to back that up. People accused of the most serious crimes are in some ways like the least likely to be rearrested when they're out pending that case. And we have ample evidence before us in many, many stories, but even within our membership, of people who are wrongfully convicted. So, I think it's something for us all to think about. And, it's like, as a society, can we accept the idea that the accusation of a very serious charge or very serious harm, is that enough for all the protections of the presumption of innocence to go out the window? Because it feels like, and what our members have experienced is like, that's the case. You are charged with murder, and therefore we cannot possibly release you pending your trial. So you have to try to prove your innocence while you're stuck on Rikers, and then you get convicted and exonerated 25 years later, having lost those 25 years. So I guess to wrap up, I'll just say I had the experience a few years ago of going to South Africa, and while there visiting a prison with someone who had been incarcerated at that prison, and we had the oddest conversation where we realized like we couldn't, our ways of talking about bail were really dissonant, because they were sort of treated bail as a thing you pay. They were talking about it in a positive way, as sort of like, well, like, I was so scared the judge wouldn't set bail, and we were like, what? And what they meant was that they were scared. They were scared of remand being, sort of this other possibility, but that bail was like a thing you pay. And I think that, we in the U.S. and certainly in New York, and I can't speak for elsewhere, but have an experience where people are talking about, clearly our collective experience about bail when we talk about it is a thing you don't pay, a thing that holds you in. And there's been some debate today about whether or not people should be held in or not. But the idea that bail is remand is sort of like the default that we're operating from, and so I think that continues to be a deficit in the implementation.
And you highlighted a few different things, and I think there's something to say about the use of jails and what people experience while there. And it was pretty clear that the legislative intent was to create alternatives, right? To say mandatory, most cases, people charged with virtually most nonviolent felonies and misdemeanors would be subject to a release, with the understanding that instead of jail, you could use alternatives to incarceration, where it steps in some of these pretrial services that we're talking about. Another thing that was included in the statute, at least upon when it was revisited in 2020, was this use of mandatory programming, right? It became something that courts could explicitly order for the folks who appear before them, the accused individuals. They had this option to say, while you are released, waiting for your trial, you can participate, I'm ordering you to participate in some sort of program that meets some sort of need, right, of that individual. And what I would like to ask is how, there seems to be consensus amongst the folks here, right? We talked about the human interaction. We talked about, supervised release and so much more, right? And linking people to these things. How have you, and I'm sort of giving this to anyone who feels comfortable responding, is how have you seen that particular part of the statute used? And then maybe share, what about that has been going well or not?
So one thing that's clear, just looking at the Rikers population, and I'm sorry that I can't speak for the rest of the state, the Rikers population has a minimum of 60% of the population has a diagnosed mental illness. And I'm not talking about people who have never been diagnosed. So we are mass incarcerating people who have a mental illness, who have clearly fallen through the cracks. And unfortunately, many of them are dying at Rikers Island. So the last death, which was less than a week ago, was a suicide. And so I do think the legislature, especially with the 2022 amendments, recognized that there is mental illness that is issues that are being unaddressed in the criminal system, and I can't call it the criminal justice system, but in the criminal system. And so just with the one amendment to CPL 510, there was a reminder to judges. And one of the most important reminders is, as a condition of release, a judge can send someone to a treatment court or to a court for judicial diversion, which is under Article 216 of the Criminal Procedure Law. And that's right now, it's for substance use disorders. Hopefully, it will expand into, some people have a mental illness and they don't have the substance use component also. But it's a recognition that people who are mentally ill, the fallback and the default should not be jail. But what's very clear for those who have a serious mental illness diagnosis also is that many of them don't have supportive housing or they've lost it. And so there are issues with resources. And I'm not saying that it's easy to treat someone with a mental illness, and this is just for someone who doesn't even have a criminal case pending. But when you add on the criminal case that's pending, and you send them to a place like Rikers Island, even on a misdemeanor, they're going to come out worse. So many people decompensate when they're at Rikers Island. So if eventually the case gets dismissed because of 30-30 or because the complainant's uncooperative or they get an acquittal, they come out and they're far worse. They've decompensated. I mean, I was just looking at a file this morning. This man has been requesting a mental health visit and DOC is not producing them, right? They are cut off from their psychiatric medication, even though Correctional Health Services has acknowledged that there's a psychiatric illness and that this person needs psychiatric medication, and he's not being produced. So when we're talking about why are we sending people to Rikers Island on charges where they might eventually get an acquittal, or it's a misdemeanor, they might eventually get a 3-month jail sentence because it's a misdemeanor and the DA sees that that's the value of the case. And so what happens then is we just continue with the cycle. We continue with the cycle. And with the 2022 reforms, there's another reminder to judges. You can have pretrial services assist with if someone has to go to the hospital under the mental hygiene law 943 for an observation and evaluation, you can use pretrial services to assist with that. But it's a real recognition that this is a problem and that courts should really, at a minimum, pause before they just default and send someone to jail.
Good. Martha, do you?
So for us, we've had that aspect of, as part of our supervision as a mental health counseling or substance abuse counseling, and that we monitor that. We make sure that they get involved in the program. A lot of it is scary for the individual to even make that phone call. We assist in making that. But the judges have been utilizing that in Wayne County for over 20 years. And they acknowledge that there are other barriers that affect a person's life. And if they can get that help, then they very much are open to using that. Right now, it's probably 10% of our cases have that as part of it. The other ones that are certainly the release with the lowest conditions, if they're if we are in talking to that person, even they feel that those issues need to be addressed, we certainly help them do that. And it really affects the success of their case, but the success of their life, really.
One of the things that I truly enjoy, I really enjoy listening to the success stories of people who otherwise would have not experienced success in their lives, but for like your program and the program that you're talking about in Wayne County. And I remember during a lot of the debates and discussions about pretrial services and how, I mean, there was a statistic that was presented during the discussions at the Capitol about how 80+% of the people, if provided with good pretrial services, will return to court. And there is no disputing that. I believe that. I believe if there's someone who's on that phone, who's attending to the needs of people, whether those needs be direct needs or other familial needs, I do believe that you're going to get cooperation. I do believe that you're going to get positive outcomes. But I think if we're really serious about pushing this state forward and having, the best systems in the country, then we just have to stop rewarding our elected officials with the simple passage of things when they're not funding those things. Because you might have a robust system in New York City, but that's not the case in 57 other counties, which is why 57 other counties have to struggle to come into compliance and do the best that they can. Can it be better? Absolutely, yes. I've been living at the bottom of the hill from the state capitol for over 20 years. And it's one unfunded mandate after another, forcing local municipalities to struggle to comply with those unfunded mandates. But if we're serious about change, about reform, then it's not just, hey, here's the signing of the piece of legislation. And by the way, signing a piece of legislation without also writing a check, it's called palm card reform. They can talk about it in their next campaign for re-election, but they're not really serious about it. Because if they were serious about it, they'd invest in people.
I just want to remind folks that we're in a few minutes. I'm going to open it up for Q&A. So if anyone wants to tweet a question or just wants to think through what you would like to ask, just giving a few minutes warning. Sarita, did you want to comment?
Yeah, I mean, I think that what you touched on in terms of the need to fund the services that are required, whether they're attached to a law or because they've been needed for for decades, absolutely. And where I think where some disingenuousness from some of the most vocal opposition is exposed is that it's the same people who were sort of most ready to pounce on bail reform as the boogeyman have been trying to defund social services for the last, and succeeded for the last several decades. So so there's, that is true, and it is also questionable then why the response to saying bail reform, there were things needed in addition to bail reform, why that would then go to weaken bail reform or put more things back in the bail eligible bucket rather than invest in services. Because I think if all the energy had been let's invest in services, that would have been a very different discussion. We would have come out with a budget that left bail reform intact and funneled a respectable amount of money into services that could possibly compete with what we have invested in law enforcement over the last many, many years. And just to give, an example of this, I think that in New York City, and we recognize that New York City is not the only city in the state and is an outlier in certain ways, but it serves as an example that New York City's jail population has been declining with, some ticks up and down around COVID that were non-typical, but has been declining for 25 years, is 75% of what it was 25 years ago. And we left all of that money in corrections. They did not lose a dollar. And so, yes, are people still struggling? And there's a gap in services? Yes, because nobody's had the political will to say, we don't need all those correction officers. And so instead, you know, what would have been really positive would be that people were struggling and we weren't seeing it because we could just hide them in jail. Now people are still struggling and we're seeing it more on the streets because it's harder to hide them in jail. And so the response then needs to be, how do we get that money back? You know, it's not that we don't have money. I mean, in New York City, certainly, I will speak for the city that I live in, we have money. It is about the willingness to shift it from where it is not needed to where it's needed.
Okay, I would like to open it up, give an opportunity for either people here in the room with us to ask questions, if anyone has a question on their mind for one or all of our panelists. And for those who are maybe watching remotely, feel free to use the Twitter handle NY Bail Conference if you'd like to ask your question that way. Otherwise, I'll keep asking questions because I do have a few. I will say, you know, I wonder, you know, there's this conversation around resources, right? And I'm hearing an infrastructure that is supportive of social services, right? So this is where those dollars would go. Are there any other hard, concrete, as specific as you can get, examples of where such dollars would go? I also heard from Awinna's earlier comment about just sheer number of people to supervise the larger number of people who are now on supervision awaiting their trial. So any other concrete examples that you all can share? Sarita, if you.
Oh, I don't want to, I'll go after you and me because I just spoke.
I think housing is incredibly important because I think when judges see on someone's CJA form that the person doesn't have stable housing, the fallback is jail. And that is just completely, it's illogical to me, but that's what a lot of judges do. I think supportive housing for those with the mental illness, we really need resources there. I mean, supportive housing is incredibly important because I think once you have a physically safe place to live, right? Because I've represented I represented a young man who had agoraphobia, and so you know, and just like being in a crowded setting. So I think stable housing is important, and then obviously, you know, the mental health services, more job opportunities, but these are all very difficult for people who've been incarcerated, whether it's intermittent or not, who don't have the stability in their lives anyway. And you know, unfortunately, as a public defender, and I was in private practice, but as a public defender, what we see the most is people who have lengthy criminal conviction records. And I've had that discussion. I see a couple of public defenders here. I've had that discussion pre-bail reform on misdemeanor cases where someone will say, I want to fight this case, but bail is set. They can't even make $750 bail, and they say it's better for me to plead guilty, to take the 30 days rather than wait a year to go to trial on a misdemeanor. And that's how you keep building up, right, that record. And so that's the harm that I think is going to take a long time to undo, because you have this one individual who's taken out of his or her community, right? And all of a sudden a child loses a parent, right? Or a mother loses a son who's helping with medical assistance or whatever it is. And that one person can have such an impact within that community. And this is what happened pre-bail reform. And then you build up, you know, pretty much a damaged record. And this is what we as defenders and as advocates have been talking about in terms of why bail reform was so necessary and why mass decarceration really has to end. Because it's just, it's the one person, but the impact is huge.
Sarita, did you, oh, sorry, I was going to go back to Sarita to give her an opportunity.
I just want to quickly just double down on the supportive housing, increasing options, especially in a borough like Staten Island where the options are very limited, and also accessible mental health services, efficient, quick mental health services. Just from a pretrial services perspective or experience, we'll get someone on, released to us, and then, they have a high level of mental health diagnoses or present a certain way in our office. At times it's been violent, and then we find out that, a day later they're arrested in another jurisdiction, in another borough, and then 3 days later they're arrested again. So it goes back to the earlier comment around, what is needed for people who exhibit these behaviors and have this illness, having access so that the person is prevented from, being rearrested. That person obviously needed help and they needed quick access to help, but kept getting arrested and is in Rikers right now on remand. And I do know that person does have severe mental health issues that are likely going untreated and not taken care of.
If I can ask the question, and I'm just curious because I find this aspect of the conversation fascinating. In New York City, when people are arrested on, it could be like disorderly conduct offenses or petty offenses, they're receiving desk appearance tickets, right? Is that?
Many of them are, as long as they fit the statutory criteria, so.
So when, are they connected to services upon arraignment when they're, because your pretrial services, are they being connected then and there?
Well, pretrial services can't be ordered
Yes.
until a judge orders it
Yep.
as a condition of release. And so we're back to the 20-day arraignment period on appearance tickets. The Brooklyn DA has a pre-arraignment diversion program. And so if people want to avoid getting their case even docketed after the arrest, they can sign up for a program so that they don't even have a docketed case, and then the case is over, as long as they do whatever it is that's required of them. But if they do come through arraignments on an appearance ticket, just because it's an appearance ticket eligible offense, meaning it's most likely a misdemeanor, it's supervised release is not utilized because it would just be too much and overkill for that type of person who probably has never been arrested before.